Welcome. This is Marina Moltop with the Center for Work-Life Law. Thank you for joining us for Please Don't Fire My Patients, how to support your pregnant patient's ability to earn an income and stay healthy on the job. This webinar is a reproduction of a Grand Rounds lecture delivered in fall 2016 at a dozen medical schools nationwide, including the University of California, Harvard, Stanford, Baylor, the University of Pennsylvania, the University of Pittsburgh, the University of Chicago, and others. Our presenter today is Liz Morris, the Deputy Director of the Center for Work-Life Law and an adjunct law professor at the University of California, Hastings College of the Law. Liz's research and advocacy seek to advance gender equality at work and in education, including promoting protections for pregnant and breastfeeding women. Liz has written numerous articles on the topic she will address today, including one published in the American Journal of Obstetrics and Gynecology, which outlines steps that prenatal care providers can take to support their pregnant patients at work. I'll now turn it over to Liz to tell us more.
Thanks, Marina, and thanks to everyone listening in today. Several years ago, the Center for Work-Life Law formed a working group of attorneys, doctors, midwives, and other prenatal care providers to study the issue of how healthcare providers can best support their pregnant patients at work. We heard over and over from prenatal care providers that you all wanted to help your pregnant patients facing workplace challenges, but you'd never been offered the training on the laws that can have a really significant impact on your pregnant patients, on your patients' ability not only to maintain a healthy pregnancy while continuing to work, but also to maintain their jobs, their health insurance, and their ability to support their growing families. The attorneys and other advocates in our group work together with the medical professionals to come up with effective strategies that you can implement to help your pregnant patients at work. One of the primary ways in which you can help your pregnant patients is by helping them to secure any reasonable accommodations that you believe they need at work to be able to continue working safely and comfortably. Now, when I say accommodation, I'm talking about adjustments or modifications to the work environment or the way that the job's performed that allow the patient to do her job. So this includes things like the ability to eat snacks during the day, to have a stool to sit on, for example, while checking out customers at the cash register, to have a schedule change, to be able to attend prenatal care appointments with you. Unfortunately, many people work under conditions where, because they're simply unlucky or have a boss who's unwilling to accommodate, they have to really fight or sometimes simply just cannot get what they need to stay healthy at work. Take, for example, the woman we see here, Armanda Legros, who's pictured here with her son. Armanda worked for an armored truck company for 2 years before becoming pregnant. Then at 6.5 months pregnant, she pulled a muscle in her stomach, and her doctor advised that she not engage in heavy lifting so that she wouldn't exacerbate that injury. Armanda's doctor gave her a note so advising, and she took the note to her employer. Armanda's boss took one look at the doctor's note and immediately fired Armanda. Now, there was another option in that workplace. That same company had previously provided an accommodation for another employee who couldn't engage in heavy lifting because of an injury to his back. Because she was fired, Armanda had a hard time putting food on the table and struggled to get by. Now, she was quote, lucky in that she was able to get the assistance of attorneys from an organization in New York called A Better Balance, and they were able to help her get her job back. But she, of course, had an extremely difficult time in the interim, and many women don't even have that type of ultimate outcome. The Center for Work-Life Law's working group on pregnancy accommodation found that healthcare providers can have a meaningful impact on work outcomes for pregnant women, work outcomes that have a real significance for the economic security of women and the families that they support. Healthcare providers who have general familiarity with the laws and know where to go for additional resources can strengthen their patients' ability to continue earning an income while maintaining a healthy pregnancy. Unfortunately, our working group also found that healthcare providers, even when intentions are good, which of course they always are, um, sometimes healthcare providers can do things that undermine these things. Specifically, providers who aren't trained on how to write work accommodation notes can cause their pregnant patients to lose income or their health insurance or sometimes even their jobs. So I'm going to talk more about this and provide concrete steps that you can take and resources that you can rely on to ensure that you're best supporting your patients in their ability to support their families. First, let's take a look at the learning objectives. First, after the lecture, you'll understand the laws that protect pregnant women in the workplace, including those that require employers to provide pregnancy and lactation accommodations and leave. Second, you will understand the role that you as the prenatal care provider play in supporting your pregnant patient's abilities to earn an income while maintaining a healthy pregnancy. Third, you will understand the unintended negative consequences that inappropriately written work accommodation notes may have for your patients. And finally, after the lecture, you will have learned how to write work accommodation notes for pregnant patients that are medically and legally appropriate, as well as where to go for additional resources. So let's go ahead and jump in. Before we get into the laws and the practical steps that you can take, since this is geared toward an audience of scientists, I'd like to start off by discussing the data that explain why this matters. Today, most women, 61%, work during pregnancy, and women are working later into their pregnancies than ever before. Of first-time mothers who work, 88% work into their third trimester. This chart shows us women who are breadwinners and co-breadwinners for their families from 1967 on the left to 2012 on the right. The green represents the breadwinners and the blue represents the co-breadwinners. So you can see as of 2012, a record 40% of all households with children under the age of 18 include mothers who are either the sole or primary source of income for the family. And then another 22.4% were co-breadwinners, meaning that they earn between 25 and 49% of their family's income. So what this chart basically shows us is that the income of most mothers is crucial to their family's economic well-being. And that's especially true of low-income women who are even more likely to be their family's primary breadwinner and are even more likely to be single mothers. So this means that if a pregnant woman isn't given the accommodation she needs to be able to continue working, then her family's economic security will suffer. ACOG has not yet provided significant guidance on work restrictions for pregnant women, but here is what they do say in the guidelines for perinatal care. A woman with uncomplicated pregnancy usually can continue to work until the onset of labor. Women with medical or obstetric complications of pregnancy may need to make adjustments based on the nature of their activities, occupations, and specific complications. It also has been reported that pregnant women whose occupations require standing or repetitive strenuous physical lifting have a tendency to give birth earlier and have small for gestational age infants. So basically, there's a lot of room for your discretion in making these determinations. Now, we do have data on the need for accommodations, which has been taken from a survey of 1,072 women. This chart is based on that self-reported data. You see the first column lists 4 types of accommodations that may be needed by pregnant women. So we have breaks, change in schedule or time off for prenatal visits, change in job duties, like less lifting or more sitting, and then some other kind of work adjustment. The second column shows us the percentage of women who reported that they needed that particular type of accommodation. And as you can see, a majority of women did report that they needed accommodations. The third column shows us the percentage of women who, though they did believe they needed the accommodation, did not ask for it. And we believe this is because of fear of repercussions like retaliation, or because they simply didn't know that they had a legal right to receive an accommodation. And you can see that the numbers here are rather significant. in terms of people who believe they needed an accommodation but did not ask for one. Finally, the last column shows the percentage of women who do make a request but their request is denied. In other words, their employer simply says no. So we can see there that most accommodation requests, when made, are granted, but still more than 250,000 women are denied their requests every year nationwide. And that doesn't include the women who simply do not request an accommodation. So we believe that, even though they believe they need one, so we believe that the unmet need is even greater than that. So when someone's denied an accommodation, one of two things happens. They either continue working without it against your best medical judgment, or they stop working, which can have very real negative consequences that can impact them and their children for years to come. On the other hand, women who receive accommodations are able to continue earning an income for their families and maintaining a healthy pregnancy. All right, so now that we understand this from the employee's perspective, what about the employer's perspective? There's good news here, which is that the data on disability accommodations and workplace flexibility show that when accommodations are provided, productivity increases, employee retention increases, employee commitment increases, workplace safety increases, absenteeism goes down, and employer insurance costs, or insurance costs for the employer, go down. Accommodations for pregnancy are always temporary, and they're typically low cost or cost free. Also, because employers have long been required to accommodate employees with disabilities, employers already have pre-existing processes, paperwork, professional staff in place to work with employees to identify and then provide needed accommodations. All right, so with that background, let's go ahead and talk about the law. As a general rule, nationwide, pregnant women have a right to receive accommodations under a legal right to receive accommodations under many circumstances. But there are still some gaps in the law that leave some women unprotected and therefore vulnerable to job loss when they need modifications at work to stay healthy. To make matters a little bit more complex, the extent to which pregnant women enjoy workplace protections varies from state to state. Now, the way that you write the work accommodation note for your pregnant patient can be critical in ensuring that she receives the accommodation that she needs. There are three sources of law to be aware of that may provide a legal right to accommodation for your pregnant patient. The first is the Pregnancy Discrimination Act. The second is the Americans with Disabilities Act, and these are both federal laws, meaning that they apply nationwide, they apply in every state. And then finally, there's a number of state laws that apply only, of course, in the states where they were passed. And we're going to discuss each of these three sources of law. Let's start out by talking about the Pregnancy Discrimination Act, which again is a federal law that applies in all states to employers that have 15 or more employees. Now, before getting into the requirement that pregnant women be accommodated under this law, it's important to flag for you that not only may pregnant women be entitled to accommodations because of this law, but they also have a right to work free from discrimination, not to be discriminated against or treated worse by their employers because of their pregnancy. So it's helpful for you to be familiar with the types of things that constitute illegal pregnancy discrimination so that you can flag them for your patients and recommend that they seek legal advice if something that is illegal or unfair or wrong has happened for your patient. So what does it mean to have a right to work free from discrimination? First of all, employers cannot refuse to hire someone because they're pregnant. Second, employers can't deny employment opportunities because of pregnancy. Like, for example, deciding not to promote a pregnant woman to a position that she would otherwise be the top candidate for based on the assumption that she's going to no longer be committed to her job after she has the baby. Employers can't take negative action because of pregnancy or childbirth. So this means the employer can't engage in harassment based on pregnancy, like, for example, making derogatory comments or threats. Employers can't treat pregnant women worse than other employees by, like, for example, imposing strict punctuality requirements on pregnant employees when other employees are not penalized for tardiness. Um, Employers can't force pregnant women out on leave when they're able to do their jobs, even if the employer believes it's, quote, helping the employee. Benevolence is not a defense to discrimination. So for those of you who may be thinking, wow, these sound like really extreme cases, please know that these things happen regularly. And I'm sure there are some of you who are thinking, yeah, of course this stuff happens. But for those of you who think that these sound like extreme cases, I want you to know that these things happen regularly in all industries across all income and class levels. So if you know that any of these things have occurred for your pregnant patient, or if something that seems wrong or unfair or similar to one of these things has occurred, you should advise your pregnant patient to contact a legal hotline. And we operate a free legal hotline. I'll provide you information for that at the end so that your patient can speak with an attorney about her situation. Okay, so now in addition to prohibiting the forms of discrimination based on pregnancy and childbirth that we just discussed, the Pregnancy Discrimination Act also says that women affected by pregnancy, childbirth, or related medical conditions shall be treated the same for all employment-related purposes as other persons not so affected, but similar in their ability or inability to work. Okay, so what does this legal jargon mean? It means that pregnant women must be treated the same as other employees who are not pregnant, but similarly limited in their ability to work. And what does it mean to be treated the same? Just last year, the U.S. Supreme Court decided in a case called Young versus UPS that this law provides a comparative right to receive accommodations. In other words, when an employer has a policy and practice of accommodating its employees for non-pregnancy or non-childbirth related reasons. So for example, accommodating people with on-the-job injuries or people with non-pregnancy related disabilities, then that employer must treat pregnant women the same and provide them accommodations as well, because pregnant women cannot be treated less favorably than non-pregnant employees. So as you can see or hear, this is a convoluted, not straightforward standard that leaves a lot of room for interpretation. The problem with that is that employers may not be clear on what the law requires them to do because it's murky, and so that can lead to unlawful differential treatment, makes it difficult for pregnant women to assert their rights. An entire lecture could be given on this legal standard alone, but the bottom line is that pregnant women have a comparative right to accommodations when non-pregnant employees receive accommodations, and that applies in many cases, though of course not all. The second federal law I mentioned that may provide pregnant workers with a right to accommodation is the Americans with Disabilities Act, a law I'm sure you've all heard of, and that provides that employers with 15 or more employees must provide reasonable accommodations to employees with disabilities unless to do so would cause an undue hardship. So notice that an employee is entitled to an accommodation under this law only if she has a disability. Now, a disability is a physical or mental impairment that substantially limits one or more major life activities, including significant back pain, gestational diabetes, debilitating morning sickness, perinatal depression, and other typical pregnancy-related conditions. So the definition of disability under this law is broader than we normally conceive of that term, because a disability doesn't have to be a long-term condition to meet the standard under this law. It only needs to be a physical or mental impairment that substantially limits one or more major life activities. Major life activities can include things like walking, standing, thinking, working, eating, sleeping, and so forth. Major life activities can also include the operation of normal bodily functions. So the normal functioning of the digestive, endocrine, reproductive, respiratory, musculoskeletal, and so forth systems, substantially limited. That means as compared to the rest of the population. And the condition has to be considered before any ameliorative measures like, for example, medication have been administered. So this is rather broad and includes many typical pregnancy-related conditions, including those I just mentioned and others. All of that said, the fact that someone is pregnant on its own doesn't mean that she's entitled to an accommodation under this law. There has to be some impairment. Now, again, I'm not just talking about high-risk pregnancies or, quote, abnormal situations. Many typical pregnancy-related conditions are covered, but it's important that it be made clear to the employer that there's some form of impairment if the employee is going to be entitled to an accommodation under this law. And that's something we're going to talk about how to do in a little while. The second thing that I'm sure you noticed about this law is that accommodations must be provided to employees with disabilities when they're needed, quote, unless to do so would cause undue hardship. So an undue hardship is a significant burden or expense. It's very difficult for employers to show that an undue hardship exists, but there may be circumstances, of course, where an undue hardship would exist for a particular accommodation. So, for example, let's say that there's a bus driver who's unable, your patient, who's unable to sit for more than 20 minutes at a time. It would be unreasonable and present an undue hardship for her to ask that she be able to pull over the bus every 20 minutes, get outside, go outside, stand on the curb for 15 minutes while the passengers are sort of looking out the window wondering why the bus isn't moving. The bus needs to stay on schedule, the passengers need to get where they're going. That would not be reasonable and present an undue hardship. However, the fact that that particular accommodation would pose an undue hardship does not mean that there's no reasonable accommodation available for this person. For example, this particular patient may be able to move to an office job temporarily where she sells tickets while intermittently sitting and standing. The key is to be creative in finding solutions that will keep the employee working. Now, the two laws that we just discussed, the Pregnancy Discrimination Act and the Americans with Disabilities Act, provide protections nationwide, but as you've now learned, they don't provide a perfect right to accommodation under all circumstances, without question. So there are a number of states that have laws requiring employers to provide accommodations for pregnancy, regardless of whether there's some condition or disability beyond pregnancy, regardless of whether non-pregnant employees receive accommodations. There's just a right to receive accommodations for pregnant employees. And those states are listed here, and they include California, Colorado, Delaware, the District of Columbia, Illinois, Maryland, Minnesota, Nebraska, New Jersey, New York, North Dakota, Rhode Island, Utah, and West Virginia. Now, pregnant women who work in these states have a clear right to receive accommodations. Keep in mind, though, that some of these laws don't apply to very small employers. It's worth noting there are several other states that I haven't listed here that have some level of additional protection for pregnant women who need accommodations at work, though they still don't provide a clear right in all circumstances to receive accommodations. Also, keep in mind that this list is current as of April 2017, but new laws pass in this area every year. So the best practice really is to consult resources that I'm going to provide you at the end of this webinar to learn about the specifics of the laws that apply in the state where your patients work. Now, as a practical matter, when an employee needs an accommodation, the way this works is that the employee asks the employer for the accommodation she needs, and both parties, the employer and the employee, should engage in a good faith, meaningful exchange to determine an effective, reasonable accommodation. Whether the employee is entitled to an accommodation will depend on coverage under the various laws we just discussed, but even where the employee has a right to be accommodated, she's often or typically not entitled to her first choice accommodation necessarily if another accommodation would also be effective. But the employer cannot require the employee to take leave if there's an accommodation available that would allow her to continue working. Also, on a related note to that, it's important to remember that where an employee has not asked for an accommodation and she's still able to do her job, she has a right to continue working. The employer cannot decide that it believes that she's unable to work because of pregnancy perhaps the employer thinks it's dangerous or something like that, if the employee is still able to do her job. It's the employee's choice to continue working. Now, when an employee has asked for an accommodation, employers are generally allowed to ask for medical documentation of the need for accommodation, and that's where you all come in. The way that you write the work accommodation note is important in ensuring that your patient gets the accommodations that she needs. As I mentioned earlier, it can mean the difference between, on the one hand, receiving the necessary accommodation, being able to continue earning an income, maintaining a healthy pregnancy, or on the other hand, losing one's income, health insurance, and possibly even one's job. So to address the problems that can arise with ineffectively written work accommodation notes, our working group designed state-specific tools that you all as healthcare providers can use in each state to help your pregnant patients best utilize the pregnancy accommodation laws available to them in that state. And these resources are available on our website, www.pregnantatwork.org. The website, pregnantatwork.org, houses note writing guidelines for each of the 50 states and DC based on the laws specific to those states, and those guidelines advise on how to write an effective work note, and also we provide model note language. For many states, we also provide a tool that automatically generates the text of an effective work note based on information that you input about your patient's condition. So the interactive tool and the guidelines are all available at www.pregnantatwork.org. The team that put together the guidelines available on pregnantatwork.org was composed of attorneys as well as healthcare providers whom we've listed here. Our recommendations on how to write effective work notes have been published in the Green Journal and the Gray Journal in the articles that you see listed here at the bottom of your page. The recommendations that we made in those journal articles are the same as those that appear on the Pregnant at Work website. So I'm going to take you through step by step what you'll need to include to write a legally and medically appropriate work note, as well as what you will hopefully be able to avoid in your work notes. Now, one more note before getting into before getting into the specifics. I appreciate how busy all of you are and how many you prenatal care providers are and how many demands that you have on your time. So not only do I thank you for tuning in to view this presentation today, but I also want to reassure you that the guidelines we created are meant to be as succinct and easy to use as possible while still providing, of course, all of the necessary information. Okay, so let's jump into writing a work accommodation note. The first thing that you're going to want to do is state that your patient is pregnant, and this is to trigger the protections of the Pregnancy Discrimination Act, or if you have a law in your state's law. So you would state, for example, I'm the treating physician, midwife, etc., for Jane Doe, who's under my care for her pregnancy. That's pretty straightforward. The next thing, if your patient works in a state that does not provide a clear right to accommodation, so a state that I did not mention earlier as having a state law, you're going to want to identify your patient's medical condition and the bodily system impaired. And this is meant to trigger the requirement that an accommodation be provided under the Americans with Disabilities Act. We want to make clear to your patient's employer that she has a condition that constitutes a disability under that broad definition that I described a few minutes ago. So here are examples of the type of language that you could use to identify your patient's impairment. My patient has gestational diabetes, an impairment of the endocrine system. My patient has sciatica or severe back pain, an impairment of the musculoskeletal system. My patient has migraine headaches, an impairment of the cardiovascular and nervous system. Now, this is an important step in most states to trigger the ADA's protections, but keep in mind that in states that do have a clear right to accommodation, you don't want to include this information because you want your patient's privacy to be maintained. So again, those states are California, Colorado, Delaware, District of Columbia, Illinois, Maryland, Minnesota, Nebraska, New Jersey, New York, North Dakota, Rhode Island, Utah, and West Virginia as of April 2017. Now we have, again, state-specific guidelines and model language intended to make this easy at pregnantatwork.org, and you can download the guidelines for your state specifically. Regardless of where your patient works, it is always important to remember that your patient is not giving the note that you write for her to another healthcare professional. She's giving it to one of her coworkers, sometimes a direct male supervisor who may have negative feelings towards pregnant women in the workplace. So even where you do have to identify a medical condition in your note, take care to do so in a way that protects your patient's dignity. So, for example, avoid graphic details to the extent that that is possible. Okay, next, in states where you have to identify a medical condition to trigger the protections of the Americans with Disabilities Act, the very best notes will make clear to the employer that the condition that you've identified is an impairment that limits the major life activities by actually identifying what major life activities are substantially limited by the medical condition. So you could say, that your patient's medical condition, Ms. Doe's medical condition, substantially limits her ability to eat, sleep, bend, reach, stand, walk, live, communicate, concentrate, think, perform manual tasks, care for herself, work, or any other relevant major life activity. Okay. Everything else that I'm going to tell you now to include in your note applies in all 50 states and DC. Whether there's a pregnancy accommodation statute or not. Okay, so the next thing you're going to want to do in all states is precisely identify your patient's limitations. So here are some examples of the type of language that you would want to use to precisely and specifically identify your patient's limitations. Patient is unable to stand for more than 1 hour without 15 minutes of sitting. Patient may not be exposed to fill in the specific toxin. Patient may not lift more than 50 pounds more than 3 times per day. Notice how detailed, precise, specific this language is. None of these examples use language that is vague or overly broad. So here's some examples of language that is vague that you would want to avoid when writing a work accommodation note. My patient needs light duty. Instead, it's better to state the precise limitation that your patient has. Like, for example, she can only be on her feet for X hours per day. No stress. No employer can guarantee no stress. So this is simply going to cause a risk that your patient will be sent out on leave, sent out of work. Finally, no physical activity. Again, you want to be more specific. There are very few jobs that require no physical activity at all. So you want to say exactly what physical activity you think your patient may be engaging in that she should not be engaging in. It's important not to impose limitations that are not medically indicated, because if there's no accommodation available, your patient could be sent out on unpaid leave or even lose her job. Now, as you heard at the beginning, I'm an attorney. I'm not a medical professional, and I certainly wouldn't presume to tell you what's best for your patients. The doctors that I work with in our working group have reviewed existing data on activity restrictions and have asked me to share the message that prenatal care providers should be thoughtful about whether the restrictions that are being imposed are truly evidence-based, because as you're learning here today, those restrictions can have a real impact on your patient's ability to earn an income. So I'm going to just read to you now from the Green Journal article that was cited earlier, and you can see the site again at the bottom of the page. Although many prenatal providers commonly prescribe activity restrictions, including bed rest or lifting or work restrictions, the evidence for these interventions is lacking. Substantial epidemiologic data exist assessing the effect of occupation and work activities such as lifting in pregnancy. These studies have been evaluated in a number of meta-analyses, including by the Cochrane Collaborative, and there's no evidence to conclude that activity restrictions in average risk women will decrease the risk of miscarriage, preterm delivery, hypertensive disorders, or growth restrictions. So that's the message from my medical colleagues. If you're interested in additional information, I encourage you to check out the Green Journal article. But the important point to keep in mind is not to impose limitations that are not medically indicated, because if no accommodation is available, the patient could be sent out on unpaid leave or even lose her job. Okay, the next thing you're going to want to do with your work accommodation note is affirmatively state that your patient is able to continue working without an accommodation. So Jane Doe is able to continue working with a reasonable accommodation. And this is actually very important because it ensures that the employer is crystal clear on this point and will deter the employer from sending your patient out on leave. Obviously, you'll omit this step if you are recommending leave, but leave should be recommended only as a last resort, as we'll discuss in just a few minutes. The next thing that you're going to want to do is to describe the medically advisable reasonable accommodation that you recommend. And a reasonable accommodation is a change in the workplace that would accommodate a pregnant woman by enabling her to safely perform her job without imposing an undue hardship on the employer. So here's a list of accommodations that are often helpful during pregnancy. More frequent or longer bathroom breaks, breaks for increased water intake, breaks for periodic rest, seating, assistance with manual labor, temporary transfer to a less strenuous or hazardous position, provision of an accessible work site, acquisition or modification of equipment, job restructuring, a part-time or modified work schedule, reassignment to a vacant position, mechanical or coworker assistance with lifting. You'll see here a page from a 5-page chart that we've created with our medical partners, which you can find in the guidelines available at pregnantatwork.org. This chart provides examples of reasonable accommodations that may be appropriate for all of the typical pregnancy-related medical conditions that our medical partners could come up with. So of course what you'll recommend for your patient will depend on her condition and her workplace, but the chart is meant to be helpful in generating ideas for the types of accommodations that you may want to recommend. So that's available on the guidelines at Pregnant at Work. I've mentioned several times now that there may be problems with recommending leave. And sometimes as a provider, you may think, well, my patient can't do her normal job, so she should go out on leave. Or sometimes your patient will ask you to put her out on leave. Leave can be a form of reasonable accommodation under the Americans with Disabilities Act. And there may be other laws entitling your patient to take leave from work. However, if the patient can continue working safely with a reasonable accommodation, then that is almost always preferable. First of all, the U.S. is the only industrialized country in the world that doesn't have a guarantee of paid leave for childbirth, and most people don't have any pay available to them when they are on leave, and those who do generally only have a limited amount of pay available. Second, leave that's used during pregnancy may eat into the leave that may be available after the baby is born for recovering from childbirth, bonding with the baby, and establishing breastfeeding. So you use it up during pregnancy, it may not be left or may be substantially diminished for after the baby is born. And then finally, if you put your patient out on leave and there is no leave available under the law for that patient, or if the leave runs out, she could end up losing her job. Now, if that happens, we may have legal arguments to try and help your patient get her job back. So you should definitely advise her to seek legal advice. I'll give you the number of our hotline at the end, and other resources. But clearly, this is a situation that your patient would want to avoid. So generally, recommending leave should be done only as a last resort, and your patient should understand the negative consequences potentially associated with taking leave. Now, I know some of you may be thinking, well, my patients often ask me to put them out on leave. And so I guess what I'm encouraging you to do is to discuss with your patient what's best for her. But please keep in mind that oftentimes women don't know that they have a legal right to receive an accommodation, or they mistakenly believe it's unsafe for them to continue working, or they haven't thought of a creative solution in their workplace that would allow them to continue working and staying healthy. Or they simply just don't know that they may use up their leave time during pregnancy and potentially lose their job after the baby's born. So you can play a role, and I know how pressed for time you all are, but you can play a role in helping your patient to consider these issues, particularly with low-wage workers or less savvy workers, because in the end it may end up saving your patient's job, or at the least encourage your patient to call us and we will help to work through these issues. So now that we've covered the potential problems with taking leave, I want to reiterate what I said earlier because it's very important. An employer cannot require a pregnant employee to take leave if she's able to do her job. That's unlawful pregnancy discrimination. Pregnant women who can do their jobs can't be pushed out of work because the employer believes it's best. Okay, the final thing that you're going to want to include in your note is to provide the start date of the accommodation and the probable duration. Ms. Doe's medical condition and related limitation began on October 26, 2016. At this time, I anticipate that she'll need an accommodation until December 9th, 2016. Now, if the end date of the accommodation you're recommending is uncertain, you can list a date by when you will reevaluate your patient. The date can be extended or changed in the future, but it is important to put some end date down so that the employer can plan accordingly. Okay, so let's take a moment here to discuss a hypothetical case, and we'll use the hypothetical to pull all of this together into a single note. So let's say your patient works at a grocery store and she has back pain during her third trimester. In talking to your patient, you learn that her primary duties involve checking customers out at the cash register and from time to time stocking shelves, particularly in the produce section. Very rarely she has to move heavy boxes around in the back of the store to get boxes of fruit ready to stock the shelves, but that's rare. And someone is typically available to help her to do this, or would always be available to help her to do this. She spends most of the day, therefore, on her feet at work, except for the breaks that she takes. Now, her pregnancy is progressing well, and she could technically continue to do all of these things from a medical perspective if the alternative was to go out on unpaid leave. However, she'd be much more comfortable and less stressed if she could sit down more frequently and not engage in that occasional heavy lifting. In talking to your patient, you discover it would be possible for her to sit down at the cash register, and that there's always somebody who would be available to assist her on those rare occasions where she has to lift the boxes of fruit or whatever it is. Okay, so here is a sample work note, and the text that you see in black would apply in all states. The text that you see in red identifies the medical condition and should only be used in those states that do not provide a clear right to accommodation. So if I didn't list the state as having a pregnancy accommodation statute earlier, then you'd want to include the language that you see here in red. But in states where there's an unquestionable right to accommodation, you would omit the language in red identifying the medical condition in order to protect the patient's privacy. So here's the note. To whom it may concern, I'm the treating physician for Jane Doe. I diagnose Ms. Doe, who is pregnant, with musculoskeletal pain, an impairment of the musculoskeletal system. This medical condition substantially limits Ms. Doe's ability to walk, sit, bend, and lift. So that language in red triggers the protections of the Americans with Disabilities Act. Due to her condition, Ms. Doe should not lift more than 25 pounds without assistance and should be allowed to sit when possible. Ms. Doe is able to continue working with a reasonable accommodation. In other words, do not put my patient out on leave. I recommend that she be allowed to receive coworker or mechanical assistance with lifting greater than 25 pounds and be allowed to sit at the cash register when checking out customers. Ms. Doe's medical condition and related limitation began on November 28, 2016. At this time, I anticipate that she'll need an accommodation until February 1st, 2017. And remember, that date can be changed later if necessary. Thank you. Sincerely, Dr. Helpful. So that would be you. Okay, as I mentioned earlier, we have a model note available as part of our note writing guidelines that pulls all of this together along with step-by-step instructions on writing notes in each state and a chart that provides suggested reasonable accommodations for that list of typical pregnancy-related conditions. We also have an interactive tool that allows you to answer questions about your patient's medical condition, and then it automatically generates the text of a medically and legally appropriate work accommodation note. So check that all out at www.pregnantatwork.org. I want to wrap this up by telling you a little bit about the laws surrounding two other issues that are relevant to your patients. The first, the right to take leave from work, and then the second, the right to express breast milk in the workplace. So first, the Family and Medical Leave Act, or the FMLA, is the federal law, I know you've all heard of it, that provides up to 12 weeks per year of job-protected leave for serious health conditions or for the birth of a new child. Now, job-protected means that following the leave, the employee must be placed back in the same or a substantially similar job. The leave under the FMLA is unpaid. The FMLA does not require that it be paid, but any health insurance benefits that are provided by the employer must be maintained by the employer as they always have been when the employee is out on leave. Now, the Family and Medical Leave Act can be used for several reasons relevant to your patients. First, it can be used intermittently for prenatal care appointments. Oh, pardon me, I seem to have a problem with the screen here. Let me just go back to where we were. Okay, so just mentioned that the FMLA could be used intermittently for prenatal care appointments. The FMLA can also be used if time off is necessary due to conditions related to pregnancy, like, for example, morning sickness. It can also be used to take time off for baby bonding after the baby is born, and recovery from childbirth. And keep in mind that for purposes of baby bonding, that applies equally to men. Men are entitled to up to 12 weeks per year of leave under the FMLA, including for baby bonding. Now, there are strict eligibility requirements with this law. Employees are covered by the law only if their employer has 50 or more employees within a 75-mile radius of your patient's work site, and only if they have worked for the employer for at least a year and have worked on average 1,250 hours within the previous year, which is about 24 hours per week on average. Now, the FMLA is an important law for pregnant and postpartum women, of course, but there are shortcomings. First of all, due to strict eligibility requirements that I just described, 2 in every 5 women of childbearing age is not covered at all by this law. In other words, it doesn't provide them anything. Second, it's limited to only 12 weeks of leave per year, and if that time is used up during pregnancy, then it's not available following pregnancy for bonding and breastfeeding and recovery. And then finally, leave, as I mentioned earlier, is unpaid under the FMLA. There's no requirement that it be paid. And as a result, taking full-time leave is out of reach for many women, particularly those who are working low-wage jobs and people who are living paycheck to paycheck. And so these factors combined all help to explain why in the US, 1 out of every 4 women who are employed returns to work within 2 weeks of giving birth. Now, as you all know, taking leave after the baby's born is important for recovery from childbirth, it's important for bonding, and it's important for establishing breastfeeding. And indeed, women frequently cite return to work and inhospitable work environments as primary reasons for early weaning. Now, many new mothers work in environments where their managers don't understand breastfeeding needs, and even under normal circumstances, they're not allowed to take breaks. Normal circumstances meaning breastfeeding aside, they're not allowed to take breaks, even to do things like use the restroom without permission. People also have workplaces that are inhospitable to breastfeeding in the sense that there's no clean or private place to pump breast milk. So for example, think of somebody who's working at a fast food restaurant. Their only option, unless their manager is sympathetic, could be trying to quickly pump during their lunch break in a dirty bathroom stall. Researchers at the University of Minnesota found, and this is based on a study of 550 women, that 41% of women are not provided reasonable break time for expressing breast milk. 55% don't have access to space, to private space, and fully 60% of women don't have access to both private space and break time. Now, the same study found that low-income women and single mothers are significantly less likely to have access to these accommodations, of course, mirroring the socioeconomic patterns of breastfeeding. And the study also found that workplace accommodations for breastfeeding significantly predict breastfeeding outcomes at 6 months postpartum, as well as breastfeeding duration up to 20 months postpartum. So with that in mind, I'd like to bring your attention to the laws that require accommodations for nursing mothers. You'd think, given those abysmal accommodation rates, that we don't have any, but we do. First, the Affordable Care Act included a provision called the Break Time for Nursing Mothers Law, and that requires employers to provide a private non-bathroom space to breastfeeding workers, as well as reasonable break time, as often as needed to pump breast milk, to express breast milk throughout the workday within the first year of the baby's life. Now, this law applies to hourly employees who are entitled to overtime compensation. So again, it doesn't cover everyone, but it does cover many employees. Now, under some circumstances, breastfeeding women may also be entitled to accommodations under the Pregnancy Discrimination Act, which is the law that we discussed earlier that provides a right to accommodations when non-pregnant employees are receiving accommodations. Similarly, breastfeeding employees may be entitled to accommodations when other non-nursing, non-breastfeeding, non-lactating employees are receiving accommodations. There are also a number of states that provide rights for break time and private space for pumping or sometimes other accommodations that are needed for breastfeeding women. So it's important when you're discussing nursing with your patients to mention that they may have rights to express breast milk at the workplace and suggest to them that they seek more information about those rights. Again, I'll give you resources at the end. This is an extremely important thing to flag for your patients because, again, return to work and unsupportive work environments are both statistically associated with early weaning. So the pregnantatwork.org website I've been referring you to, that includes guidelines for writing effective work accommodation notes for pregnant patients, also includes a document providing guidance on how you can support your breastfeeding patients at work. It provides a little bit more detail than what we've covered here today, including guidance for writing notes for breastfeeding workers who need accommodations. So I hope that you have found it interesting to learn about the laws that protect your pregnant patients and your pregnant colleagues at work. Of course, the laws are complicated and they're nuanced, so there's no expectation that you be an expert on these laws, but I hope that you will feel more comfortable now flagging issues for your pregnant patients who may not even know that they have these types of rights at work. So here are resources you may want to refer your pregnant patients to. The first that you see here, pregnantatwork.org, is the same website where the guidelines for writing work notes is housed. It also provides The website also provides a number of practical resources for your patients, how to talk to their employers, information about their legal rights. And I've listed here also the Center for Work-Life Law's legal hotline, phone number and email address, hotline@worklifelaw.org or 415-703-8276 at the very least. This is a free legal hotline. If you think that something illegal is happening or that your patient could benefit from more information about her legal rights, please just encourage her to call our organization, and we'd be happy to provide information as well as attorney referrals nationwide. Here we have resources that may be of value to you, the healthcare provider. Of course, the website where you can find the note writing guidelines for each of the 50 states and the interactive note writing tool. That's pregnantatwork.org. I've also listed a useful website, babygate.abetterbalance.org, that provides state-by-state overviews of all of the laws that affect pregnant and parenting workers. Finally, you can call us at the Center for Work-Life Law directly if you have a question about how to write a note or how to use the guidelines. We're available at 415-565-4640. We are more than happy to talk through any of these issues with prenatal care providers. So many thanks for taking the time to dive into the law with me and for your commitment to providing holistic care to your pregnant patients.